Hi, and welcome to the Changing Tides of Business, Navigating the Seas of Change. We're going to be starting a Bad Boss, Nasty Boss series and talking about recruiting and retention strategies and how do we stop workplace harassment and bullying. My special guest today is John McNamara, founder and CEO of McNamara and Associates. Welcome, John.
Well, thank you. Thank you for having me.
Briefly, can you just tell me a little bit about your company? Because it's so much. I've read your, we'll put up your website later, but you've got so much on there.
Well, I founded the company 28 years ago, and we are an organization and management development firm headquartered in Monmouth County, New Jersey. We have since expanded our operation here to Southwest Florida, and we've work with organizations of all sizes across all industries throughout the United States in the areas of HR support, executive coaching, training, and program development. Most of the work that we've done throughout the United States has been in the area of workplace bullying and harassment awareness, and helping organizations and employees protect themselves against those types of behaviors.
All right. Well, thank you. That just leads me right into it. By the way, my name is Lois Bolin from Success Fulfillment, Inc. And as John just said, we're going to be talking about ways to save money for your company and to save your employees' sanity. Let's make our focus today, as we said, it's going to be on why harassment and bullying matters. Currently, we're amid one of the harshest and most competitive talent markets. 83% of recruiters believe that attracting and retaining talent is a growing issue, which we have that all across the country. And research shows there are 5 reasons for leaving their current job positions. Is it the mission, the opportunity, the manager, the work pace, or is it money? And ironically, money's always the last one. That's never really the issue, but it comes down to the manager and the workplace, which kicks us off into harassment and bullying. So let us know. I know there's a form there's a format that employees, not employees, but employers has to have certain systems in place to protect themselves, right?
Yes. Let me focus on the state of Florida for a moment. State of Florida, there is no mandate for employers, private and public employers, to have any kind of processes in place. However, the EEOC, which is the Equal Employment Opportunity Commission, which is the government agency responsible for handling all complaints of harassment and discrimination, they've strongly suggest you do have policies, training, and reporting mechanisms in place. Now, that being said, on the federal level, the federal government in 1998, as a result of 2 lawsuits in particular, which we can talk about in a little bit, mandated that any employer with 50 or more employees must have a policy in place that outlines appropriate versus inappropriate behavior and the consequences for violating that policy, and the policy needs to be disseminated to all employees throughout the organization. Second thing that they mandated was having a user-friendly complaint procedure in place that allows employees to file a complaint if they find that they're the victim of any form of harassment or discrimination. And thirdly is training. Training employees and managers on harassment awareness and how to prevent it. Now, interestingly, when that mandate was put in place in around the 2 cases were in 1998, the mandate was put in place, I think, at the end of 98, beginning of 99. What was interesting was that most employers with 50 or more employees decided to develop a policy if they didn't have one already, develop a complaint procedure if they didn't have one already. The problem was that many employers failed to do the training. And what you saw at that time was a spike in cases that otherwise would have been won that were lost simply because the employer did not do any kind of training. So that gives you a little bit of a background on the public and private sector.
Does training have to be yearly, or?
No, every state is different. Some states it's annual, some states it's every 2 years. What I always recommend is train your employees once, and then every 6 months for all new employees that come into the organization, conduct additional training.
Okay.
Now, in Florida, when it comes to any kind of government agency that is ultimately run, or I should say the governor has oversight over.
Right.
Governor DeSantis, when he, the first day he was actually brought into office, signed an executive order that mandated that people take all government agencies within the state that ultimately wind up reporting into his office must begin to take this topic very seriously. He expected people to have policies in place. He expected complaint procedures in place. He expected training to be conducted. And also, he expected that there be some sort of a individual, whether it be HR or a harassment officer, responsible for handling these complaints. So he's one of the governors in this country that is very serious about this topic.
What if the HR person happens to be the person doing most of the harassment?
Oh, that becomes a problem. If there's not as I mentioned, a user-friendly complaint procedure in place where an individual has numerous avenues to go through to file a complaint, you're pretty much leaving yourself wide open for liability. Because if it's the harasser that is the person that you're expected to report the complaint to, that becomes a real problem. And I'll go back to what I was mentioning earlier about the 2 cases that brought.
Oh yeah, those were very interesting. We had such great conversations on this. You just are a wealth of knowledge. I'm just letting you go do your thing.
Thank you. Well, the 2 cases, one was a case right here in Florida, Farrager versus Boca Raton. And Farrager was a female lifeguard that was hired by the city of Boca Raton in 1985. She worked for the city for 5 years. There were 2 supervisors, male supervisors, that were very inappropriate in comments that were being made, comments and jokes about females on the beach, the female lifeguards, et cetera, et cetera. And it got to a point after about 3 years where one of the supervisors in particular decided he was going to kick it up a notch. He was going to take it from the jokes and the comments to some physical behavior.
Wow.
Things like groping, touching, intentionally rubbing up against Farrager, really inappropriate stuff. It finally got to a point, no matter how many times she said stop, he just kept it up. It got to a point where she just couldn't take it anymore. She spoke to a friend of hers whose dad happened to be an employment attorney and who overheard the conversation. And the dad basically said to her, you should never, ever allow this behavior to exist. And he volunteered to take the case on her behalf, and they filed in federal court in Florida. While that case is being heard, there was a second case in the Midwest, Burlington Industries versus Ellis. In that case, Kimberly Ellis was a young female sales rep for Burlington Industries. She was on a fast track. She was very, very good at her job. She reported into a gentleman who was much older than her, who was very inappropriate in his comments, stupid things, jokes about, things like some of the comments that I recall were, hey, you want to make more sales? Unbutton one more button on your blouse. Or you want to make more sales? Wear shorter skirts.
Yeah, that's really old school.
Very old school. So, and those comments never really bothered her. What bothered her the most was there was a situation where they went on a business trip and they met in a hotel lobby bar before dinner, and they were having a conversation, and he allegedly touched her knee, and she pulled away, and he profusely apologized and said, I would never do anything. I know I make jokes and comments, but I would never do anything to intentionally harass a female or be out of line, because I wouldn't want anyone to do that to my wife or my daughter. When he apologized, everything was fine. They went back to work. A few weeks later, she got promoted. 6 months at that time, the statute of limitation was 6 months from the time of an incident to the time you file a complaint. 6 months, almost to the date, she decides to file a harassment complaint against Burlington Industries and her supervisor. And what prompted it was that night in the hotel lobby bar. So that case goes to federal court in the Midwest. Going back to the Farragut case, the court asked 3 questions of Boca Raton. Number 1, do you have a policy against harassment? And the response was, we're not sure. And the court said, well, not sure is not a good enough answer. You have a week to either submit a policy or tell us you don't have one. Number 2, do you do any training around harassment for your employees? And the answer was no. And the third question was, do you have a complaint procedure in place that Farragut could have utilized to file a complaint against her supervisors rather than having to bring the case to court? And the answer was sure. Anybody that has a complaint files the complaint with their supervisor. Well, to your question earlier, who was the alleged harasser? It was her supervisor. Slam dunk, Boca Raton, you lose. Farragut, you win. You fast forward back to the Midwest case. The court asked the same 3 questions of Burlington Industries. Number 1, do you have a policy against harassment? And they said, yes, we do, and here's a copy of it. They asked Ellerth, are you aware of this policy? Her response was, yes, I am. In fact, they send it to us with our first paycheck every year as a reminder. Okay. Do you do any training around harassment? And they said, yes, we do. Here's a copy of the training. Here's how often we do it. And the judge asked Ellerth, are you aware of this training? Have you been through this training? And she said, oh, yes, several times. Okay, and that was a little strange. And the last question was, do you have an internal complaint procedure that Ellerth could have utilized before bringing this case to court? And they said, yes, we do, and here's a copy of it. And the complaint procedure allows anyone that feels that they're a victim to file a complaint with any level of management or HR up to and including the CEO. Ellerth, were you aware of this complaint procedure? And she said, yes. And they said, well, why wouldn't you file your complaint internally before taking it to court? And she said, I just didn't feel comfortable filing within the organization. Slam dunk, Ellerth, you lose. Burlington Industries, you win. Not only did she lose the case, she lost her job, and she had to pay the court costs for Burlington Industries.
Okay.
And with that, when after those 2 cases, the courts got together and said, look, we have certain guidelines that are meant to protect employees against these types of behaviors. However, we need to strengthen these guidelines to protect the truly innocent victims like Farragut, and at the same time, reduce the number of these frivolous lawsuits that are being filed from people like Ellerth. So what they said was that's where they decided all employers with 50 or more employees must have a policy in place, a complaint procedure, and begin to train their employees on this topic.
Is harassment the same thing as bullying?
That's a great question, because I get asked that question quite often. Yes and no. There's a very fine line between harassment and workplace bullying. One of the forms of workplace harassment is hostile work environment.
Yeah.
Workplace bullying, more times than not, in the cases that I've seen and been involved with, are rise to the level of hostile work environment. Now, what's interesting is that there has been legislation that has gone through the Senate, through the Congress for years around coming up with some sort of a law against workplace bullying. No state and federally, nobody has yet written into law anything regarding the workplace bullying because of that fine line. You know, the feeling, I think, is we've got this this harassment law in place, and the harassment law includes hostile work environment. So it's going to be really difficult to differentiate between the two.
Is there a statute of limitations? And I'm going to get to a couple examples. Some of them are so bad I really don't want to say them on air. But is there a statute of limitation before someone can, let's say they've been through all of these procedures or they don't have the procedure, whatever the case, is there a statute of limitation?
Yeah, that's another great question.
I'm so good.
Prior to, yes, you are. Prior to some of the high-profile cases that we've seen over the last probably 10 years, Harvey Weinstein, Matt Lauer, prior to that, there was a consistent federal standard of you have 6 months to file any kind of a grievance, a legal grievance with the EOC. From the time of the infraction, you have 6 months to file a claim. Since the Harvey Weinstein and the Matt Lauer incidents, each state has now adopted their own statute of limitation. Some states it continues to be 6 months. Some states it's 12 months. Some states there is no statute of limitation. And I'll give you a great example of that. I was brought in. One of the things that I may not have mentioned earlier when I introduced the company is I myself am also an expert witness in court cases around harassment and discrimination. And I was brought into a situation, I think it was 4 or 5 years ago, where a prominent physician had an alleged relationship with a nurse 22 years ago. And after the Matt Lauer and Harvey Weinstein situation, this nurse decided she was going to come out in the open and file a complaint with the hospital that they worked at regarding this relationship that she felt was forced upon her. And it was very interesting. You know, you're going back 22 years. The surgeon was now 80-something years old. And I had to go in and investigate all of the circumstances and the facts of the case. And what we found was that there was definitely a relationship. She's claiming that it was an unwelcomed relationship. He's claiming that it was not an unwelcome, it was welcome. So it was a he said, she said.
Yeah.
And unfortunately, the hospital wound up paying a considerable amount of money to this female nurse just to get her to back off of any kind of legal challenge. But she would have, if she decided to file a claim legally, it would have been heard. That's how serious the courts are now about these topics.
Well, and how many years was that?
22 years.
Good Lord, have mercy. Okay. I have a couple of examples that don't necessarily fit, and we didn't talk about this earlier, so I'd give you any But there are some cases where bullying, okay, here, bad boss, nasty boss. Okay, we talked about that. And what if there's just a nasty person who happens to be your boss? And there's a difference, right?
there's a big difference. A bad boss is someone. I'll give you an example. Someone that maybe is overzealous and puts a lot more pressure on you in terms of the expectations. Bad boss is someone that requires too much of you outside of your job description. A nasty boss is someone that's going to bring the behavior to the level of hostile work environment, constant screaming at you in front of your coworkers, in front of your customers, in front of third parties, demeaning comments, comments about your looks, things prying into your private life, which is nobody's business. Or even, I've seen examples where a boss and a subordinate have a good personal relationship, and that personal relationship, for whatever reason, goes south. Now, the things that employee confided in about he or her relationship or personal life, now that supervisor uses that against them in a way that's demeaning. For example, now spreading rumors about them to the other workers in the organization, or flaunting situations that were confided in them. Really bad stuff. That to me, that's a nasty boss.
Yeah.
And that's a boss that will, if an individual wants to file a claim of hostile work environment, I believe that in most cases, that claim is going to be upheld.
I have a list of several comments, and I'm just going to kind of just throw some out in generalities, because I wanted to ask about a class action suit. Is that ever kind of possible? So let me just throw this out. Chief deputy publicly told a subordinate they must really enjoy the smell of crap because their boss wears diapers and soils them all day. Is it appropriate for a deputy to harass individuals about their medical issues and attempt to obtain results and forms from doctors without the consent of the employee? Well, I think we know what that answer is. Is it appropriate for the chief deputy to corner an employee and try to make the employee talk ill of other employees? And some of these are worse than that. And when someone is allowed to take home the employee's records and someone else gets a hold of the addresses and sends very nasty information to the home of these employees. These are just a few of the things when I just started asking around. How do people deal with that psychologically? This has just got to be this. I don't care how strong you are; it's got to wear you down.
Absolutely, and again, those are really good classic examples of where those bosses are creating a hostile work environment, and those are definitely illegal examples.
Yeah.
The one about trying to pry into someone's medical records, et cetera, et cetera. That's not only creating a hostile work environment, because that's a HIPAA violation, and that can bring some pretty hefty fines.
If there have been so many going on in one place or one company, is there such thing as a class action suit to try to get to stop it, or you just have to individually bring it up?
The most cases that I've seen, you first have to have someone step up and file a complaint individually. And if there are a number of other people that have been victims of the same type of behavior, you can then take it to a class action level.
Wow. I'm just stunned. I'm sitting here just like going, oh my God, these poor people. And my heart, I can't even stand it. So go ahead. I'm sorry.
No, what I was going to say is the way these cases work, you first have to file a complaint with the EEOC.
That was all right.
The EEOC will investigate the complaint and determine whether or not there's validity. Now, at any time during that process, you can request, you can withdraw your complaint with the EEOC and request from them a right to sue letter.
A right to sue letter, okay.
Because, the EEOC is your first step.
Okay.
And if for whatever reason the EEOC is taking too long or, they're not working to your satisfaction, that's when you request the right to sue. You go to a private attorney and then you file your complaint.
And this right to sue letter lets this attorney know and the courts know that they tried to do their due diligence with the EOC and it was too long. Is
too
that pretty
long,
much?
Or they weren't satisfied with the way the case was being handled.
I have right to sue letter. I do have that on there. I'm like, okay.
Now, those situations that you outlined for me a few minutes ago, those are really, in my opinion, my professional opinion, those are really egregious.
Yeah, that's not even the bad ones.
And I mean, I just don't understand how people get away with it. But I will say this, in all of my years handling complaints, investigating situations, serving as an expert witness, it's very, very difficult for victims to step up to the plate many times. And they allow this kind of behavior to exist out of fear of retaliation, fear of it not being believed, fear of being ostracized, there's so many reasons why. And I think it takes a really strong person to stand up on their own. More times than not, what I've seen is the victim confides in a family member or a friend, and more times than not, it's a friend.
Mm-hmm.
And that friend is the one that gives them the kind of support they need and the kind of push they need to step up and stop this behavior from taking place.
You got into this business because you saw your mother. Is that right? I don't know if I should bring that up. We don't have to do that. We can edit that out. I just know that you have a heart for this.
Yeah, I do. I'm very passionate about this topic because you're right. When I was a very young boy, my mom worked in a retail environment, and her boss was your typical harasser. I'm going to be nice. I'm going to use the right word. And I watched it. I actually watched it, and it was heartbreaking. And as I got older and I reflected back on that, I said to myself, to me, I'm sorry, that is unacceptable. And unacceptable for anyone, male or female. See, that's the other thing. These cases, when they go to court, the court doesn't look at the gender of the people involved. They look at these cases gender neutral, meaning that it doesn't matter whether it's male against female, female against male, same gender against same gender. It's based, the case is decided based on the facts of the case, not the genders involved. But yeah, I had a tough time with watching my mom being harassed. Yeah.
Well, God bless your mother because she led to you. You've done something, and on your website, the amazing corporations that you've dealt with and the type of training that you do. So we're going to kind of wrap this up at a close, but I hope you'll come back and we could maybe set it because there's so much to unpack in all of this.
There really is. I mean, I could sit here with you for hours and just talk about, the different forms of harassment, the different types of harassment, the legal responsibilities. And one other important thing I think to add to this particular podcast is what people don't realize is that 25 years ago, 30 years ago, if you were the harasser and you got sued, the company more times than not would defend you. And if in fact the company was negligent in any way, the company would get hit with the punitive damages and the compensatory damages. That's not the case anymore.
Mm-hmm.
Now, yes, compensatory damages are paid by the organization if the organization is found to be at fault in any way. Punitive damages, however, can be paid by, part of them can be paid by the organization, but the majority of it is going to get paid by the harasser. And that's something new. That's something within the last 15 to 20 years that we began to see take place in the court systems. So people that think, well, okay, so I got caught, I'll go to court and I'll defend myself. Guess what? You better have a bank book with you when the court decides your fate, because you're going to wind up paying punitive damages.
How about give us your website and how people can get in touch with you?
Sure. My website is www.McNamara, McNamara Associates, all one, McNamara Associates, all one word, .com. And you can always reach me. I have my cell phone with me 24/7, which is the best way to get me. I know that personally.
Yeah, you're always on call, baby.
Yeah, which is the best way to get me, and that's 908-209-0830.
All right. Well, I just said baby. Excuse me. I didn't mean that personally.
I didn't take any offense. Thank you.
That's Southern kind of thing. All right. Well, thank you for being here. We're going to call you back. My name is Dr. Lois Bolin, president of Success Fulfillment, talking about our Bad Boss, Nasty Boss series. I hope you'll join us next time.
Thank you for having me.
Thank you.